Judicial Review. Requisites of Judicial Review. APEN. 1. Actual case or controversy. It involves a conflict of legal rights, assertion of opposite legal claims susceptible of legal resolution. It must be both ripe for resolution and susceptible of judicial determination, and that which is not conjectural or anticipatory, or that which seeks to resolve hypothetical or feigned constitutional problems. 2. Proper party. One who has sustained or is in immediate danger of sustaining an injury as a result of the act complained. To have standing, one must show that 1. He has suffered some actual or threatened injury as a result of the alleged illegal conduct of the government. 2. The injury is fairly traceable to the challenged action. And 3. The injury is likely to be redressed by a favorable action. 3. Earliest opportunity. Constitutional question must be raised at the earliest possible opportunity. 4. Necessity of deciding constitutional questions. As long as there are other bases which courts can use for decisions, constitutionality of the law will not be touched. Thus, courts should refrain from resolving any constitutional issue unless the constitutional question is the least mota of the case. Angelo Rafael petitions the SC or Supreme Court to nullify House Bill number 4738, which abolishes the Judicial Development Fund and replaces it with the Judiciary Support Fund, JSF. The funds from JSF shall be remitted to the National Treasury, and Congress shall determine how the funds will be used. Unlike the JDF or Judicial Development Fund, the spending of which is exclusively determined by the Supreme Court, Rowley argues that House Bill number 4738 infringes Supreme Court's fiscal autonomy. Is the petition meritorious? No, there is no actual case or controversy. The court cannot speculate on the constitutionality or unconstitutionality of a bill that Congress may or may not pass. It cannot rule on mere speculations or issues that are not ripe for judicial determination. Filing of bills is within the legislative power of Congress and is not subject to judicial restraint. Locus standi versus real party in interest. Locus standi, character of the plaintiff. One who has sustained or is in imminent danger of sustaining an injury as a result of the act complained. Real party in interest, the party who stands to be benefited or injured by the judgment in the suit, or the party entitled to the avails of the suit. Legal nature has constitutional underpinnings for locus standi. Party in interest, a concept of civil procedure. As to the issue involved under locus standi, whether such parties have alleged such a personal stake in the outcome of the controversy, or to assure that concrete adverseness which sharpens the presentation of issues upon which the court so largely depends for illumination of difficult constitutional questions. Under party in interest, whether he is the party who would be benefited or injured by the judgment, or the party entitled to the avails of the suit. Francisco et al. Versus House of Representatives. Locus standi in cases involving taxes. A taxpayer need not be a party to the contract to challenge its validity. As long as taxes are involved, people having a right to question contracts entered into by the government. Further, the issues raised in the petition do not refer to the wisdom, but to the legality of the acts complained of. Thus, we find the instant controversy within the ambit of judicial review. Besides, even if the issues were political in nature, it would still come within our powers to review under the expanded jurisdiction conferred upon us by Section 1, Article 8 of the Constitution, which includes the authority to determine whether grave abuse of discretion, amounting to excess or lack of jurisdiction, has been committed by any branch or instrumentality of the government. Mamba versus Lara, GR 165109. Locus standi in environmental cases. In our jurisdiction, locus standi in environmental cases has been given a more liberalized approach. Recently, the court passed the landmark rules of procedure for environmental cases, which allow for a citizen suit and permit any Filipino citizen, as steward of nature, to file an action before our courts for violations of our environmental laws. Thus, the need to give the resident marine mammals legal standing has been eliminated by our rules, and it is worth noting here that the stewards are joined as real parties in the petition and not just in representation of the named cetacean species, resident marine mammals versus Reyes. Functions of judicial review. Checking. Number 1. Invalidating a law or executive act that is found to be contrary to the Constitution. Number 2. Legitimizing. Upholding the validity of the law that results from a mere dismissal of a case challenging the validity of the law. 3. Symbolic. To educate the bench and bar as to the controlling principles and concepts on matters of grave public importance for the guidance of and restraint upon the future. What is the extent of the power of judicial review in impeachment proceedings? The power of judicial review includes the power of review over justiciable issues in impeachment proceedings. Given their conceitedly political character, the precise role of the judiciary in impeachment cases is a matter of utmost importance to ensure the effective functioning of the separate branches while preserving the structure of checks and balance in our government. Moreover, in this jurisdiction, the acts of any branch or instrumentality of the government, including those traditionally entrusted to the political departments, are proper subjects of judicial review if tainted with grave abuse or arbitrariness. Chief Justice Corona versus Senate Impeachment Court. Safeguards of judicial independence. What do you understand by the mandate of the Constitution that the judiciaries shall enjoy fiscal autonomy? Cite the constitutional provisions calculated to bring about the realization of the said constitutional mandate. Under Section 3, Article 8 of the Constitution, the fiscal autonomy of the judiciary means that appropriations for the judiciary may not be reduced by the legislature below the amount appropriated for the previous year, and after approval shall be automatically and regularly released. In Bengtson versus Drulon, the Supreme Court explained that fiscal autonomy contemplates a guarantee of full flexibility to allocate and utilize resources with the wisdom and dispatch the needs require. It recognizes the power and authority to deny, assess, and collect fees, fix rates of compensation not exceeding the highest rates authorized by law for compensation, and pay plans of the government and allocate and disperse such sums as may be provided by law or prescribed by it in the course of the discharge of its functions. Judicial restraint. What is the principle of judicial restraint? It is the theory of judicial interpretation that encourages judges to limit the exercise of their own power. In terms of legislative acts, it means that every intendment of the law must be adjudged by the courts in favor of its constitutionality, invalidity being a measure of last resort. Estrada versus Sandiganbayan. Judicial and Bar Council. Composition of the JBC. 1. Chief Justice as ex officio chairman. 2. Secretary of Justice and as ex officio member. Representative of Congress as an ex officio member. 4. Representative of the integrated bar. And 5. A professor of law. 6. A retired member of SC. 7. Private sector representative. The JBC has adopted a policy that first-level court judges must first earn 5 years of service before they are considered for promotion to the RTC or higher courts. Is this policy required to be published to be valid? Yes. The assailed JBC policy does not fall within the administrative rules and regulations exempted from the publication requirement. The assailed policy involves a qualification standard by which the JBC shall determine proven competence of an applicant. It is not an internal regulation because if it were, it would regulate and affect only the members of the JBC and their staff. Thus, it is but a natural consequence thereof that potential applicants be informed of the requirements to the judicial positions so that they can comply. Judge Ferdinand Villanueva versus the JBC. Supreme Court. Appellate jurisdiction of the Supreme Court. The Supreme Court has the power to review, revise, reverse, or affirm on appeal or certiorari as the law or the rules of court may provide final judgments and orders of lower courts in 1. All cases in which the constitutionality or validity of any treaty, international or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance, or regulation is in question. 2. All cases involving the legality of any tax imposed, assessment, or toll, or any penalty imposed in relation thereto. 3. All cases in which the jurisdiction of any lower courts is in issue. 4. Or criminal cases in which the penalty imposed is reclusion perpetua or higher. 5. All cases in which only an error or question of law is involved. Procedural rule making power. Can the Supreme Court suspend its own rules? Yes. The Supreme Court has relaxed its rules in order to serve substantial justice considering a. Matters of life, liberty, honor, or property. B. The existence of special or compelling circumstances. C. The merits of the case. D. A cause not entirely attributable to the fault or negligence of the party favored by the suspension of the rules. E. A lack of any showing that the review sought is merely frivolous and dilatory. And F. The other party will not be unjustly prejudiced thereby. Toyoto Alabang versus Games. Constitutional commissions. Constitutional safeguards to ensure independence of commissions. Guarantees of independence provided for by the Constitution to the three commissions. 1. They are constitutionally created, may not be abolished by statute or its judicial functions. 2. Each is conferred certain powers and functions which cannot be reduced by statute. 3. Each is expressly described as independent. 4. Chairman and members are given fairly long terms of office for 7 years. 5. Chairman and members cannot be removed except by impeachment. 6. Chairman and members may not be reappointed or appointed in an acting capacity. 7. Salaries of chairman and members are relatively high and may not be decreased during continuance in office. 8. Commissions enjoy fiscal autonomy. 9. Each commission may promulgate its own procedural rules. 10. Chairman and members are subject to a certain disqualification and inhibitions calculated to strengthen their integrity. 11. Commissions may appoint their own officials and employees in accordance with civil service law. Civil Service Commission. The civil service embraces all branches, subdivisions, instrumentalities, and agencies of the government, including government-owned or controlled corporations with original charters. As the central personal agency of the government, it 1. Establishes a career service. 2. Adopts measures to promote morale, efficiency, integrity, responsiveness, progressiveness, and courtesy in the civil service. 3. Strengthens the merits and rewards system. 4. Integrates or human resources and development programs for all levels and ranks. 5. Institutionalizes a management climate conducive to public accountability. Capablanca acquired a permanent status as Public Officer 1 after taking the required examinations, including the Career Service Professional Examination Computer Assisted Test (CSP, CAT), given by the Civil Service. However, it was found out that the person and the picture pasted in the picture seat plan, as well as the signature therein, when he took the exam, is different from the person whose picture and signature is attached in the personal data. CSC conducted preliminary investigation. Capablanca's counsel moved to dismiss, arguing that the administrative discipline over police officers falls under the jurisdiction of the PNP and/or NAPOLCOM. Does CSC have jurisdiction and disciplinary authority over a member of the PNP? Yes. The CSC, as the central personal agency of the government, is mandated to establish a career service, to strengthen the merit and reward system, and to adopt measures to promote morale, efficiency, and integrity in the civil service. Section 12 of Administrative Code of 1987 enumerates the powers and functions of the CSC. Section 11 thereof states that CSC has the power to hear and decide administrative cases instituted by or brought before it directly or on appeal, including contested appointments, and review decisions and actions of its offices and of the agencies attached to it. Further, Section 28, Rule 14 of the Omnibus Civil Service Rules and Regulations specifically confers upon the CSC the authority to take cognizance over any irregularities or anomalies connected with the examinations. Hence, CSC acted within its jurisdiction. Commission on Elections. Cases which must be first heard and decided in division. 1. All election cases, including pre-proclamation contests, originally cognizable by the Commission in the exercise of its powers under Section 2, Number 2, Article 9, C of the Constitution. Number 2. Petition to cancel a certificate of candidacy. 3. Cases appealed from RTC and MTC before they may be heard in bank upon filing of a motion for reconsideration of the division decision. And 4. Petition for certiorari from the decision of the RTC or MTC before it may be heard in bank. Natura, 2015. Cases which the Comelec and bank shall take cognizance. 1. Motion for reconsideration of a decision of a division. 2. Petition for correction of manifest errors, alleging an erroneous copying of figures from the election return to the statement of votes by precinct. 3. Prosecution in the exercise of Comelec's administrative powers of cases involving violation of election laws. And 4. Cases when the Commission does not exercise its adjudicatory or quasi-judicial powers. Let us suppose that Congress enacted a law which amended the Omnibus Election Code, particularly Section 138, 139, 142, 143, by vesting in the Commission on Elections the jurisdiction over inclusion and exclusion cases filed by voters instead of in the courts, MTC, then RTC. Is the law valid or not, and why? The law granting the Commission on Elections jurisdiction over inclusion and exclusion cases is unconstitutional. Under Section 2, Number 3, Article 9, C of the Constitution, the Commission on Elections cannot decide the right to vote, which refers to the inclusion and exclusion of voters. Under Section 2, Number 6, Article 9, letter C of the Constitution, it can only file petitions in court for inclusion or exclusion of voters. Commission on Audit. Powers and duties of COA. 1. Examine, audit, and settle all accounts pertaining to revenue and receipts of, and expenditures or uses of funds and property owned or held in trust or pertaining to government. 2. Keep general accounts of government and preserve vouchers and supporting papers. 3. Authority to define the scope of its audit and examination, establish techniques and methods required therefor. 4. Promulgate accounting and auditing rules and regulations, including those for prevention and disallowance. Can non-governmental entities be subjected to auditing by the Commission on Audit? Yes. Such entities are to be subjected to audit when they are receiving subsidy or equity, directly or indirectly, from or through the government, which are required by law, or the granting institution to submit to such audit as a condition of subsidy or equity. As a rule, the Commission on Audit conducts its auditing function on a post-audit basis. What is the exception? Where the internal control system of the audited agencies is inadequate, the Commission may adopt such measure, including temporary or special pre-audit, as are necessary and appropriate to correct the deficiencies. Prohibited offices and interest. No member of a constitutional commission shall during his tenure 1. Hold any other office or employment. 2. Engage in the practice of any profession. 3. Engage in the active management and control of any business which in any way may be affected by the function of his office. 4. Be financially interested, directly or indirectly, in any contract with or in any franchise or privilege granted by the government. any of its subdivisions, agencies, or instrumentalities, including GOCCs or their subsidiaries. Review of final orders, resolutions, and decisions rendered in the exercise of quasi-judicial function. Supreme Court's jurisdiction over decisions of the Commission. 1. COA. Judgments or final orders of the Commission on Audit may be brought by an aggrieved party to the Supreme Court on certiorari under Rule 65, only when COA acts without or in excess of jurisdiction or with grave abuse of discretion amounting to lack or excess of jurisdiction may the Supreme Court entertain a petition for certiorari under Rule 65. CSC. In the case of decisions of the CSC, Administrative Circular 1-95538, which took effect on June 1, 1995, provides that final resolutions of the CSC shall be appealed certiorari to the CA within 15 days from receipt of a copy thereof. From the decision of the CA, the party adversely affected thereby file a petition for review on certiorari under Rule 45 of the Rules of Court. COMELEC. Only decisions of COMELEC and Bank may be brought to the court by certiorari since Article 9-C provides that motions for reconsideration of decision shall be decided by the Commission and Bank. Reyes v. Mindoro, GR 108886. Rendered in the exercise of administrative function. Certiorari jurisdiction of the Supreme Court over the constitutional commissions. Proceedings are limited to issue involving grave abuse of discretion resulting in lack or excess of jurisdiction and do not ordinarily empower the court to review the factual findings of the commissions. Aratuk v. COMELEC. Constitutional law. Fundamental powers of the state. Police power versus taxation versus eminent domain. Basis. Extent of power under police power regulates liberty and property. Taxation and eminent domain affects only property rights. Power exercised by whom? Police power and taxation are exercised only by the government. Eminent domain may be exercised by private entities. Nature of the property taken. Under police power, property is noxious or intended for a noxious purpose. Taxation and eminent domain, property is wholesome. Purpose as to property taken under police power. Property taken is destroyed. Under taxation and eminent domain, property is taken for public use. Compensation. Under police power, intangible altruistic feeling that one has contributed to the public good or general welfare. Under taxation, protection and public improvements. Eminent domain, fair market value of the property expropriated. Exercise of the fundamental powers of the state. General rule. The inherent powers are to be exercised by the legislature. Exception. These powers may be delegated to PALQ. A. President. B. Administrative agencies. C. Local government units. And D. Quasi-public corporation only for eminent domain. Police power. What are the requisites for a valid exercise of police power? For a valid exercise of police power, there must be a lawful subject and it must be executed through lawful means. There is a lawful subject when the interests of the public generally, as distinguished from those of particular class, require the exercise of the police power. It is executed through lawful means when the means employed are reasonably necessary for the accomplishment of the purpose and not unduly oppressive upon individuals. NTC versus Philippine Veterans Bank. The Metropolitan Manila Development Authority is authorized to confiscate a driver's license in the enforcement of traffic regulations. 2010 bar. The statement that the Metropolitan Manila Development Authority is authorized to confiscate a driver's license in the enforcement of traffic regulation is false. Since Republic Act No. 7924 does not grant the Metropolitan Manila Development Authority the authority to enact ordinances, the grant to it by Section 5, letter F of Republic Act No. 7924 of the power to confiscate driver's licenses without the need of any other law is an unauthorized exercise of police power. MMDA versus Kirin. Hermanic Company owned a parcel of land located at the right side of Santa Rita exit of the NLEX. The parcel of land was bounded by an access fence along the NLEX. Hermano requested that the Toll Regulatory Board, TRB, grant an easement of right-of-way, contending that it had been totally deprived of the enjoyment and possession of its property by the access fence that had barred its entry and exit from the NLEX. However, the TRB denied Hermano's request. Does Hermano have the right to demand access to NLEX by way of an easement of right-of-way? No. The putting up of the access fence on the petitioner's property was in the valid exercise of police power, assailable only upon proof that such putting up unduly violated constitutional limitations like due process and equal protection of the law. In Mirasol v. Department of Public Works and Highways, the court has further noted that a tollway is not an ordinary road, as a facility designed to promote the fastest access to certain destinations. Its use, operation, and maintenance require close regulation. Public interest and safety require the imposition of certain restrictions on tollways that do not apply to ordinary roads. As a special kind of road, it is but reasonable that not all forms of transport could use it. Clearly, therefore, the access fence was a reasonable restriction on the petitioner's property given the location thereof at the right side of Santa Rita exit of the NLEX. Although some adjacent properties were accorded unrestricted access to the expressway, there was a valid and reasonable classification for doing so because their owners provided ancillary services to motorists using the NLEX, like gasoline service stations and food stores. A classification based on practical convenience and common knowledge is not unconstitutional simply because it may lack purely theoretical or scientific uniformity. Hermano Oil Manufacturing Sugar Corporation versus Toll Regulatory Board. Power of eminent domain. How is the power of eminent domain exercised? TUCO. The power of eminent domain is exercised through the taking of private property for public use, for just compensation, and upon observance of due process. Before taking, a valid offer to buy the property must be made and a refusal of said offer. Requisites for a valid taking. The expropriator must enter a private property. 2. Entry must be for more than a momentary period. 3. Entry must be under warrant or color of legal authority. 4. Property must be devoted to public use or otherwise informally appropriated or injuriously affected. 5. Utilization of property must be in such a way as to oust the owner and deprive him of beneficial enjoyment of the property. Republic versus BDA de Castelvi. Expansive concept of public use. Public use does not necessarily mean use by the public at large. Whatever may be beneficially employed for the general welfare satisfies the requirement. Moreover, that only few people benefit from the expropriation does not diminish its public use character, because the notion of public use now includes the broader notion of indirect public benefit or advantage. Monasco versus CA. The concept of vicarious benefit. The concept of vicarious benefit abandons the traditional concept of public purpose, the essence of which is the number of actual beneficiaries. Public use now includes the broader notion of indirect public advantage. Example: conversion of a slum area into a model housing community, urban land reform and housing. There is a vicarious advantage to the society. Philstream International Incorporated versus CA. The lands of Lim Kai Chung were placed within the coverage of RA 6657 Comprehensive Agrarian Reform Law. Lim Kai Chung rejected the valuation of her lands because it was too low. The Darab conducted summary administrative proceedings for the determination of just compensation for her lands and issued its order affirming the valuation of the lands. Lim Kai-chung filed a complaint for the fixing of just compensation for her lands, claiming to want the fair market value of her lands. Does the court have the power to determine the just compensation? Yes, the court has the power to determine the proper just compensation of the properties that are subject to eminent domain. It is a judicial function and under Section 57 of RA 6657, giving special jurisdiction to the courts to have original and exclusive jurisdiction over all petitions for the determination of just compensation to landowners. The rules of courts shall apply to all proceedings before the special agrarian courts. The determination of just compensation for the taking of lands under the CARL was a power vested in the courts and not in administrative agencies, and it clarified that the jurisdiction of the SAC was not appellate but original and exclusive. Lim Kai-ching versus Land Bank of the Philippines, GR 158464. Payment of consequential damages. In cases where a property is not wholly expropriated, the consequential damages of the remaining property shall be added in the fair market value, minus the consequential benefits, but in no case will the consequential benefits exceed the consequential damages. Section 6, Rule 67 of the Rules of Court. If the subject property is being expropriated in its entirety, there is no remaining portion which may suffer an impairment or decrease in value as a result of the expropriation. Hence, the award of consequential damages is improper. Republic of the Philippines versus Soriano. Espouses Salvador owns the land where a one-story building is erected. The said land is subject to expropriation wherein the DPWH shall construct the NLEX extension exceeding MacArthur Highway. DPWH paid the spouses amounting to $685,000, which was the fair market value of the land and building. RTC issued a writ of possession in favor of the Republic, but decided to pay an additional amount corresponding to the capital gains tax paid by the spouses. The Republic, represented by DPWH, contested the decision of the RTC, adding the capital gains tax as consequential damages on the part of the spouses Salvador. Is the decision of the RTC correct? No. Just compensation is defined as the full and fair equivalent of the property sought to be expropriated. The measure is not the taker's gain, but the owner's loss. The compensation to be just must be fair not only to the owner, but also to the taker. Consequential damages are only awarded if, as a result of the expropriation, the remaining property of the owner suffers from an impairment or decrease in value. In this case, no evidence was submitted to prove any impairment or decrease in value of the subject property as a result of the expropriation. More significantly, given that the payment of capital gains tax on the transfer of the subject property has no effect on the increase or decrease in value of the remaining property, it can hardly be considered as consequential damages that may be awarded to respondent. Republic versus Spouses Salvador. If the government does not immediately pay the amount fixed by the court as just compensation, can the owner successfully demand the return of the property to him? 2016. As a general rule, non-payment of the government does not entitle private owners to recover possession of the property because expropriation is an in rem proceeding, not an ordinary sale. The delay only entitles them to demand payment of the fair market value of the property, and legal interest should be paid from the time of the taking. However, non-payment entails recovery when there is deliberate refusal to pay just compensation, or when the government failed to pay compensation within 5 years from the finality of the judgment in the expropriation proceedings. This is in connection with the principle that government cannot keep the property and dishonor the judgment. Republic versus Lim. What happens if 2 years after the government has paid full compensation, it abandoned its plan on the property? Can the owner compel the government to resell the property back to him? Yes. With respect to the element of public use, the expropriator should commit to use the property for the purpose stated in the petition. If not, it is incumbent upon it to return the property to the owner if the owner desires to reacquire it. Otherwise, the judgment of expropriation will lack the element of public use. The owner will be denied due process, and the judgment will violate his right to justice. Mactan Cebu Airport Authority versus Losada. Taxation. Tax versus license fee. Tax, levied in exercise of the taxing power. The purpose of the tax is to generate revenues. License fee, imposed in the exercise of the police power of the state. License fees are imposed for regulatory purposes which means that it must only be of sufficient amount to include expenses in issuing a license, cost of necessary inspection, or police surveillance. Under tax, if its primary purpose is to generate revenue and regulation is merely incidental, then it is tax. If regulation is the primary purpose, the fact that incidental revenue is also obtained does not make the imposition a tax but a license fee. Private acts and the Bill of Rights. May the Bill of Rights be invoked against private individuals? No. The Bill of Rights cannot be invoked against private individuals. In the absence of governmental interference, the liberties guaranteed by the Constitution cannot be invoked. Put differently, the Bill of Rights is not meant to be invoked against acts of private individuals. Irasegi versus Pa. May a husband invoke his right to privacy of communication and correspondence against his wife? Yes. The intimacies between husband and wife do not justify any one of them in breaking the drawers in the cabinet of the other, in ransacking them for any telltale evidence of marital infidelity. A person, by contracting marriage, does not shed his or her integrity or his right to privacy as an individual, and the constitutional protection is ever available to him or to her. The law ensures absolute freedom of communication between the spouses by making it privilege. Neither husband or wife may testify for or against the other without the consent of the affected spouse while the marriage subsists. Neither may be examined without the consent of the other as to any communication received in confidence by one from the other during the marriage, save for specified exceptions. But one thing is freedom of communication. Quite another is a compulsion for each one to share what one knows with the other. And this has nothing to do with the duty of fidelity that each owes to the other. Zulueta versus CA. Section 36 of Republic Act number 9165 subjected students of secondary and tertiary schools, officers and employees of public and private offices, and all persons charged before the prosecutor's office with a criminal offense with an imposable imprisonment of not less than 6 years and a day to undergo drug testing. Petitioners contend that the Section 36 is unconstitutional for violating the right to privacy, the right against unreasonable searches and seizures, and the Equal Protection Clause. Decide if the assailed provision are unconstitutional. 2016. The drug testing of students of secondary and tertiary school is valid. Deterring their use of drugs by random drug testing is as important as enhancing efficient enforcement. Random drug testing of officers and employees of public and private offices is justifiable. Their expectation of privacy in office is reduced. The drug tests and results are kept confidential. Random drug testing is an effective way of deterring drug use, and it's reasonable. Public officials and employees are required by the Constitution to be accountable at all times to the people and to serve them with utmost responsibility and efficiency. The mandatory testing of all persons charged before the prosecutor's office of a criminal offense punishable with imprisonment of at least 6 years and 1 day is void. They are not randomly picked and are not beyond suspicious. They do not consent to the procedure or waive their right to privacy. Social Justice Society versus Dangerous Drugs Board. Due process. Procedural versus substantive due process. Purpose. Substantive due process. This serves as a restriction on the government's law and rulemaking powers. Procedural due process serves as a restriction on actions or judicial and quasi-judicial agencies of the government. Requisites under substantive due process. 1. The interest of the public in general, as distinguished from those of the particular class, require the intervention of the state. 2. The means employed are reasonably necessary for the accomplishment of the purpose and not unduly oppressive upon individuals. Procedural due process. Requisite. 1. Impartial court or tribunal clothed with judicial power to hear and determine the matters before it. 2. Jurisdiction properly acquired over the person of the defendant and over property which is the subject matter of the proceeding. 3. Opportunity to be heard. 4. Judgment rendered upon lawful hearing and based on evidence adduced. Cadet 1CL Kudia was a member of Siklab Diva class of 2014 of the PMA. Professor Berong issued a delinquency report DR against Cadet 1CL Kudia because he was late for 2 minutes in his class. Kudia reasoned out that I came directly from OR 452 class. We were dismissed a bit late by our instructor, sir. The company tactical officer, CTO, of Cadet 1CL Kudia penalized him with demerits. Kudia addressed his request for reconsideration to his senior tactical officer, STO, but the STO sustained the penalty. The CTO reported him to the PMA Honors Committee, HC, for violation of the Honor Code. When the members of the HC casted their votes through secret balloting, the result was 8-1 in favor of a guilty verdict. After further deliberation, the presiding officer announced the 9-0 guilty verdict. Kudia contested the dismissal as being violative of his right to due process. Was the dismissal of Kudia a denial of his right to due process? No. Due process in disciplinary cases involving students does not entail proceeding in hearings similar to those prescribed for actions and proceedings in courts of justice. That the proceedings may be summary, that cross-examination is not an essential part of the investigation or hearing, and that the required proof in a student disciplinary action, which is an administrative case, is neither proof beyond reasonable doubt nor preponderance of evidence, but only substantial evidence or such relevant evidence as a reasonable mind might accept as adequate to support a conclusion. What is crucial is that official action must meet minimum standard of fairness to the individual, which generally encompasses the right of adequate notice and a meaningful opportunity to be heard. It is not required that procedural due process be afforded at every stage of developing disciplinary action. What is required is that an adequate hearing be held before the final act of dismissal. Kudia versus Superintendent of the PMA. Procedural due process in administrative proceedings. 1. The right to actual or constructive notice of the institution of proceedings which may affect a respondent's legal rights. 2. A real opportunity to be heard personally or with the assistance of counsel, to present evidence and witnesses in one's favor and to defend one's right. 3. A tribunal vested with competent jurisdiction and so constituted as to afford a person charged administratively a reasonable guarantee of honesty as well as impartiality. And 4. A finding by said tribunal, which is supported by substantial evidence submitted for consideration during the hearing, or contained in the records or made known to the parties affected. Bevo versus Pagcor. A former manager of the gaming department of Pagcor received a letter from B, the senior manager of Pagcor's HR department, advising that he was being administratively charged with gross misconduct. Rumor mongering, conduct prejudicial to the interests of the company and loss of trust and confidence. He was asked to submit a written explanation of the charges and that he was at the same time being placed under suspension. A was furnished a memorandum of charges against him. A's counsel requested for the copies of the statements, but Pagcor rejected on the ground that he had already been given sufficient opportunity to confront, hear, and answer the charges against him during the administrative inquiry. A subsequently received a letter informing him that he was being dismissed from service. The CSC ruled that Pagcor violated his right to due process. Is A's right to due process violated? No. As applied in administrative proceedings, the essence of due process is to be heard. This means a fair and reasonable opportunity to explain one's side or opportunity to seek reconsideration of the action or ruling complained. Due process, as a constitutional precept, does not always and in all situations require a trial-type proceeding. Due process is satisfied when a person is notified of the charge against him and given an opportunity to explain himself. In the case at bar, the petitioner could not dispute the observance of his right to due process. Vivo versus Pagcor. Hierarchy of rights. What do you understand by the term hierarchy of civil liberties? The hierarchy of civil liberties means that freedom of expression and the rights of peaceful assembly are superior to property rights. Philippine Blooming Mills versus Philippine Blooming Mills. Judicial standards of review. 1. Differential review. Laws are upheld if they rationally further a legitimate governmental interest, without courts seriously inquiring into the substantiality of such interest and examining the alternative means by which the objectives could be achieved. 2. Intermediate review. The substantiality of the governmental interest is seriously looked into, and the availability of less restrictive alternatives is considered. Strict scrutiny. Number 3. The focus is on the presence of compelling rather than substantial governmental interest and on the absence of less restrictive means for achieving that interest. Separate opinion of Justice Mendoza in Estrada versus Sandiganbayan. Void for vagueness doctrine. Discuss the void for vagueness doctrine. A law is vague when it lacks comprehensive standards that men of common intelligence must necessarily guess at its common meaning and differ as to its application. In such instance, the statute is repugnant to the Constitution because it violates due process for failure to accord persons, especially the parties targeted by it, fair notice of what conduct to avoid, and it leaves law enforcers an unbridled discretion in carrying out its provisions. People versus De La Piedra. It must be stressed, however, that the vagueness doctrine merely requires a reasonable degree of certainty for the statute to be upheld, not absolute precision or mathematical exactitude. The doctrine can only be invoked against that species of legislation that is utterly vague on its face. Example, that which cannot be clarified either by a saving clause or by construction. Estrada versus Sandiganbayan. May the void for vagueness doctrine be invoked against a criminal statute? Yes. The test in determining whether a criminal statute is void for uncertainty is whether the language conveys a sufficiently definite warning as to the prescribed conduct when measured by common understanding and practice. However, the void for vagueness doctrine cannot be used to impugn the validity of a criminal statute using facial challenge, but it may be used to invalidate a criminal statute as applied to a particular defendant. Compare and contrast overbreadth doctrine from void for vagueness doctrine. 2010. While the overbreadth doctrine decrees that a governmental purpose may not be achieved by means in a statute which sweep unnecessarily broadly and thereby invades the area of protected freedom. A statute is void for vagueness when it forbids or requires the doing of an act in terms so vague that men of common intelligence cannot necessarily guess at its meaning and differ as to its application. Equal protection of the laws. Requisites for valid classification. 1. Rest on substantial distinctions. 2. Be germane to the purposes of the law. Not be limited to existing conditions only and apply equally to all members of the same class. People versus Kayet. Tests in determining compliance with the Equal Protection Clause. 2015. Rational Basis Test 1. The traditional test, which requires only that government must not impose differences in treatment except upon some reasonable differentiation fairly related to the object of regulation. Simply put, it merely demands that the classification in the statute reasonably relates to the legislative purpose. 2. Intermediate scrutiny test. It requires that the classification means must serve an important governmental objective ends, and is substantially related to the achievement of such objective. A classification based on sex is the best established example of an intermediate level of review. Rational basis test versus strict scrutiny. Rational basis test applies to legislative classifications in general, such as those pertaining to economic or social legislation, which do not affect fundamental rights of suspect classes, or is not based on gender or illegitimacy. Legislative purpose must be legitimate. Classification must be rationally related to the legislative purpose. Strict scrutiny. applies to legislative classifications affecting fundamental rights or suspect classes. Legislative purpose must be compelling. Classification must be necessary and narrowly tailored to achieve the legislative purpose. Central Bank Employees Association versus BSP. Number 3. Strict scrutiny test refers to the standard for determining the quality and the amount of governmental interest brought to justify the regulation of fundamental freedoms. Strict scrutiny is used today to test the validity of laws dealing with the regulation of speech, gender, or race as well as other fundamental rights, as expansion from its earlier applications to equal protection. White Light Corporation versus City of Manila. 4. Intensified means test, or the balancing of interest, or equality test. Test which does not look solely into the government's purpose in classifying persons or things as done in rational basis test, nor into the existence of an overriding or compelling government interest so great to justify limitations of fundamental right, strict scrutiny test, but closely scrutinizes the relationship between the classification and the purpose based on a spectrum of standards by gauging the extent to which constitutionally guaranteed rights depend upon the affected individual's interests. Right against unreasonable searches and seizures. Requisites of a valid search warrant and warrant of arrest. 1. It must be issued upon probable cause. 2. The probable cause must be determined by the judge himself and not by the applicant or any other person. 3. In the determination of probable cause, the judge must examine, under oath or affirmation, the complainant and such witnesses as the latter may produce. And 4. The warrant issued must particularly describe the place to be searched and persons and things to be seized. HPS Software and Communication Corporation and YAP versus PLDT. Note: general warrant is not allowed. It must be issued pursuant to specific offense. Stonehill versus Diokno. LPG Dealers Association and Total Gas LPG Dealers Association filed a letter complaint before the NBI RIO, requesting assistance in the surveillance, investigation, apprehension, and prosecution of respondents for alleged illegal trading of LPG products and or underfilling, profession and or sale of underfilled LPG products. The NBI IRO, through its agent Tejamil and undercover NBI asset Antonio, conducted surveillance and test by operations, and thereafter they filed 2 applications for a search warrant to conduct a search of the Magsingal LPG refilling plant. Can personal knowledge of the witnesses of the commission of the illegal trading and underfilling of LPG be a basis for determining probable cause in search warrant applications? Yes. A finding of probable cause needs only to rest on evidence showing that more likely than not, a crime has been committed and that it was committed by the accused. Probable cause demands more than bare suspicion. It requires less than evidence which would justify conviction. The judge, in determining probable cause, is to consider the totality of the circumstances made known to him and not by a fixed and rigid formula, and must employ a flexible totality of the circumstances standard. Facts discovered during surveillance on the basis of information and evidence provided by petitioners constitute personal knowledge which could form the basis for the issuance of a search warrant. Petron LPG Dealers Association versus Ang. Instances of a valid warrantless search. 1. Visual search is made of moving vehicle at checkpoints. 2. Search is an incident to a valid arrest. Note: an officer making an arrest may take from the person A. any money or property found upon his person which was used in the commission of the offense. B. was the fruit thereof. C. which might furnish the prisoner with the means of committing violence or escaping. D. which might be used as evidence in the trial of the case. 3. Search of passengers made in airports. 4. When things seized are within plain view of a searching party. Plain view doctrine. 5. Stop and frisk precedes an arrest. 6. when there is a valid express waiver made voluntarily and intelligently. Note: waiver is limited only to the arrest and does not extend to search made as an incident thereto, or to any subsequent seizure of evidence found in the search. People v. Peralta. 7. Customs search. 8. Exigent and emergency circumstances. People v. De Gracia. One day, a passenger bus conductor found a man's handbag left in the bus. When the conductor opened the bag, he found inside a calling card with the owner's name, Dante Galang, and address, a few hundred-peso bills, and a small plastic bag containing a white powdery substance. He brought the powdery substance to the National Bureau of Investigation for laboratory examination, and it was determined to be methamphetamine hydrochloride, or shabu, a prohibited drug. Dante Galang was subsequently traced and found and brought to the NBI office, where he admitted ownership of the handbag and its contents. In the course of the interrogation by NBI agents and without the presence and assistance of counsel, Galang was made to sign a receipt for the plastic bag and its shabu contents. Galang was charged with illegal possession of prohibited drugs and was convicted. On appeal, he contends that the plastic bag and its contents are inadmissible in evidence, being the product of an illegal search and seizure. Decide the case with reasons. The plastic bag and its contents are admissible in evidence since it was not the National Bureau of Investigation but the bus conductor who opened the bag and brought it to the National Bureau of Investigation, as held in People v. Marti. The constitutional right against unreasonable search and seizure is a restraint upon the government. It does not apply so as to require exclusion of evidence which came into the possession of the government through a search made by a private citizen. When can evidence in plain view be seized without need of a search warrant? Evidence in plain view can be seized without need of a search warrant if the following elements are present. 1. There was a prior valid intrusion based on the valid warrantless arrest in which the police were legally present pursuant of their duties. 2. The evidence was inadvertently discovered by the police who had the right to be where they were. 3. The evidence must be immediately apparent. And 4. Plain view justified seizure of the evidence without further search. Del Rosario v. People. Instances of a valid warrantless arrest. 1. In flagrante delicto. 2. Hot pursuit. 3. Escaped prisoner or detainee. 4. Waiver. 5. Continuing offense. 6. Arrest after escape or rescue. 7. Arrest of accused out on bail and for the purpose of surrendering him. 8. Arrest of accused out on bail attempts to depart from the Philippines without permission of the court where the case is pending. While on routine patrol, police officers chanced upon 2 individuals chanting and in the act of exchanging something. The police officers introduced themselves and then inquired from Rebellion what he was holding. 3 strips of aluminum foil in a plastic sachet which contained white crystalline substance which looked like tawas were confiscated from them. Suspecting that the substance was shabu, the police officer confiscated the plastic sachet and brought Rebellion and his companion to the MAC station. Was there a valid warrantless arrest? Yes. There is no doubt that petitioner was arrested in flagrante delicto as he was then committing a crime, a violation of the Dangerous Drugs Act within the view of the arresting team. The essential elements in illegal possession of dangerous drugs are: 1. The accused is in possession of an item or object that is identified to be a prohibited drug. 2. Such possession is not authorized by law. 3. The accused freely and consciously possessed the said drug. And all these elements are obtaining and duly established in this case. Thus, this case comes under the exception to the rule requiring a warrant before effecting an arrest. Rebellion v. People. Villamor and Banaobra were arrested without a warrant for collecting and soliciting bets for an illegal number game locally known as loteng. The arrest was made while the two were in possession of alleged gambling paraphernalia such as a calculator, cell phone, list of various numbers, and cash in the amount of 1,500. Villamor and Banaobra contend that Villamor only went to Banaobra's house to pay a debt he owed to the latter's wife and that when Villamor gave 2,000 to Banaobra, which he placed on top of the table, Banaobra then proceeded to answer his phone when a police officer kicked the fence of Banaobra's house and arrested them. The police officers argued that the warrantless arrest was lawful because they personally saw that overt act being committed outside of the bamboo fence of Banaobra's house. The RTC held that both of them were guilty, which was affirmed by the CA. Is the warrantless arrest lawful? No. In warrantless arrests made pursuant to Section 5, Letter A, Rule 113 of the Rules of Court, two elements must concur, namely, A. The person to be arrested must execute an overt act, indicating that he has just committed, is actually committing, or is attempting to commit a crime, and B. Such overt act is done in the presence or within the view of the arresting officer. Considering that the 15 to 20 meters is a significant distance between the police officer and the petitioners, the court finds it doubtful that the police officers will able to determine that a criminal activity was ongoing to allow them to validly effect an in flagrante delicto warrantless arrest and a search incidental to a warrantless arrest thereafter. Consequently, the evidence obtained by the police officer is inadmissible against the petitioner. Villamor and Banaobra versus People of the Philippines. Stop and frisk search. Limited protective search of outer clothing for weapons. Probable cause is not required, but a genuine reason must exist in light of a police officer's experience in surrounding conditions to warrant the belief that the person detained has weapons concealed. Malacat versus CA. The waiver of unlawful arrest does not carry with it waiver of illegal searches. A waiver of an illegal arrest, however, is not a waiver of an illegal search. Records have established that both the arrest and the search were made without a warrant. While the accused has already waived his right to contest the legality of his arrest, he is not deemed to have equally waived his right to contest the legality of the search. Alcaraz versus People. Right to privacy in communication and correspondence. Reasonable expectation of privacy test. This test determines whether a person has a reasonable expectation of privacy and whether the expectation has been violated. The reasonableness of a person's expectation of privacy depends on a two-part test. First, whether by his conduct the individual has exhibited an expectation of privacy, and second, whether this expectation is one that society recognizes as reasonable. Customs, community norms, and practices may therefore limit or extend an individual's reasonable expectation of privacy. Hence, the reasonableness of a person's expectation to privacy must be determined on a case-to-case basis, since it depends on the factual circumstances surrounding the case. Ople versus Torres. Prohibited acts under the anti-wire taping law. To tap any wire or cable, or by using any other device or arrangement to secretly overhear, intercept, or record such communication or spoken word by using a device commonly known as a dictaphone or dictograph or dictaphone or walkie-talkie or tape recorder, or however otherwise described by any person, not being authorized by all the parties to any private communication or spoken word. 2. To knowingly possess any tape record, wire record, disc record, or any other such record or copies thereof, or any communication or spoken word secured either before or after the effective date of this act in the manner prohibited by this law. 3. To replay the same for any other person or persons. 4. To communicate the contents thereof, either verbally or in writing, or 5. To furnish transcriptions thereof, whether complete or partial, to any other person. Limitation on the installation of surveillance cameras. In this day and age, video surveillance cameras are installed practically everywhere for the protection and safety of everyone. The installation of these cameras, however, should not cover places where there is reasonable expectation of privacy, unless the consent of the individual whose right to privacy would be affected was obtained. Nor should these cameras be used to pry into the privacy of another's residence or business, office, as it would be no different from eavesdropping, which is a crime under Republic Act number 4200, or the anti-wiretapping law. Writ of habeas data. A writ of habeas data is a remedy available to any person whose right to privacy in life, liberty, or security is violated or threatened by an unlawful act or omission of a public official or employee, or of a private individual or entity engaged in the gathering, collecting, or storing of data or information regarding the person, family, home, and correspondence of the aggrieved party. The writ of habeas data can be availed as an independent remedy to enforce one's right to privacy, more specifically, the right to information privacy. The remedies against the violation of such right can include the obtaining, rectification, suppression, or destruction of the database or information or files in possession or in control of respondents. When is the writ of habeas data not applicable? A writ of habeas data may not be issued to protect purely property and commercial concerns, nor when the grounds invoked in support of the petitions therefore are vague or doubtful. Persons who may file a petition for the writ of habeas data: any person whose right to privacy in life, liberty, or security is violated or threatened by an unlawful act or omission of a public official or employee, or of a private individual or entity engaged in the gathering, collecting, or storing of data or information regarding persons, family, home, and correspondence of the aggrieved party. Persons who may file a petition in case of extralegal killings and enforced disappearance: any member of the immediate family of the aggrieved party, namely the spouse, children, and parents, or any ascendants, descendants, or collateral relative of the aggrieved party within the fourth civil degree of consanguinity or affinity, in default or those mentioned in the preceding paragraph. Right to information privacy. The right to informational privacy is usually defined as the right of individuals to control information about themselves. With the availability of numerous avenues for information gathering and data sharing nowadays, not to mention each system's inherent vulnerability to attacks and intrusions, there is more reason that every individual's right to control said flow of information should be protected, and that each individual should have at least a reasonable expectation of privacy in cyberspace. It is due to this notion that the court saw the pressing need to provide for judicial remedies that would allow a summary hearing of the unlawful use of data or information and to remedy possible violations of the right to privacy. Vivares v. St. Teresa's College. The cybercrime law does not require this crime private communications of sexual character between consenting adults. The deliberation of the Bicameral Committee of Congress on Section 4, letter I of the law show a lack of intent to penalize a private showing between and among two private persons, although that may be a form of obscenity to some. The understanding of those who drew up the cybercrime law is that the element of engaging in a business is necessary to constitute a crime of illegal cybersex. The act actually seeks to punish cyber prostitution, white slave trade, and pornography for favor and consideration. This includes interactive prostitution and pornography. Example, by webcam, DC Neighbor says Secretary of Justice. Freedom of expression. Limitations on freedom of expression. It should be exercised within the bounds of laws enacted for the promotion of social interests and the protection of other equally important individual rights, such as 1. Laws against obscenity, libel, and slander, contrary to public policy. 2. Right to privacy of an individual. 3. Right of state or government to be protected from seditious attacks. 4. Legislative immunities. 5. Fraudulent matters. 6. Advocacy of imminent lawless conducts. 7. Fighting words. 8. Guarantee implies only the right to reach a willing audience, but not the right to compel others to listen, see, or read. Note, obscenity is not protected expression. Political speech. Political speech is one of the most important expressions protected by the fundamental law, and have to be protected at all costs for the sake of democracy. GMA Network versus Comelec. Political speech is motivated by the desire to be heard and understood, to move people to action. It is concerned with the sovereign right to change the contours of power, whether through the election of Representatives in a Republican government, or the revision of the basic text of the Constitution. We evaluate restrictions on freedom of expression from their effects. We protect both speech and medium because the quality of this freedom in practice will define the quality of deliberation in our democratic society. Diocese of Bacolod versus Comelec. Captive audience doctrine. When a listener cannot, as a practical matter, escape from intrusive speech, the speech can be restricted. It recognizes that a listener has a right not to be exposed to an unwanted message in circumstances in which the communication cannot be avoided. A regulation based on the captive audience doctrine is in the guise of censorship, which undertakes selectively to shield the public from some kinds of speech on the ground that they are more offensive than others. Such selective restrictions have been upheld only when the speaker intrudes on the privacy of the home, or the degree of captivity makes it either impossible or impractical for the unwilling viewer or auditor to avoid exposure. Thus, a government regulation based on the captive audience doctrine may not be justified if the supposed captive audience may avoid exposure to the otherwise intrusive speech. United Transport Coalition versus Comelec. Members of the faculty of the University of the Philippines College of Law published a statement on the allegation of plagiarism and misrepresentation relative to a certain court's decision. Essentially, the faculty calls for the resignation of Justice Mario Pascual in the face of allegations of plagiarism in his work. Does this act of the faculty members squarely fall under the freedom of speech and expression? No. The publication of a statement by the faculty of the University of the Philippines regarding the allegations of plagiarism and misrepresentation in the Supreme Court was totally unnecessary, uncalled for, and a rash act of misplaced vigilance. While most agree that the right to criticize the judiciary is critical to maintaining a free and democratic society, there is also a general consensus that healthy criticism only goes so far. Many types of criticism leveled at the judiciary cross the line to become harmful and irresponsible attacks. These potentially devastating attacks and unjust criticism can threaten the independence of the judiciary. Prior restraint refers to the official government restrictions on the press or other forms of expression in advance or actual publication or dissemination. Exceptions to the prohibition of prior restraint. 1. Pornography. 2. False or misleading advertisements. 3. Advocacy of imminent lawless actions. And 4. Danger to national security. 2 kinds of chilling effects. Benign chilling effect may be caused by penal statutes, which are intended to have an in terrorem effect to prevent a repetition of the offense and to deter criminality. The chilling effect is equated with the justified by the intended in terrorem effect of penal provisions. It is permissible. Invidious chilling effect may be caused by penal laws affecting free speech and accordingly imposes a penalty that is so discouraging, thus impeding the exercise of speech and expression altogether, and is not permissible. Nestor posted on Facebook that Juan de la Cruz, a married person, has an illicit affair with Maria. Dexter liked this post and commented, "Yes, this is true. What an immoral thing to do." This post was likewise liked by 23 people. Juan de la Cruz filed a case for online libel against Nestor. Dexter and 23 other people who liked the post using as his basis Section 5 of the cybercrime law, which penalizes any person who willfully abets or aids in the commission of any of the offenses enumerated in the said law. Is this provision of the law constitutional? Explain. No. The terms aiding or abetting constitute broad sweep that generates chilling effect on those who express themselves through cyberspace posts, comments, and other messages. Its vagueness raises apprehension on the part of internet users because of its obvious chilling effect on the freedom of expression, especially since the crime of aiding or abetting ensnares all the actors in the cyberspace front in a fuzzy way. The terms aiding or abetting constitute broad sweep that generates chilling effect on those who express themselves through cyberspace posts, comments, and other messages. Hence, Section 5 of the Cybercrime Law that punishes aiding or abetting libel on the cyberspace is a nullity, but Nestor, the author, is still liable for the defamatory words he posted. Disney versus Secretary of Justice. Doctrine of Fair Comment. The doctrine of fair comment provides that every discreditable public imputation is false, because every man is presumed innocent. Thus, every false imputation is deemed malicious, hence actionable. However, such presumption does not apply when the discreditable imputation is directed against a public person in his public capacity. For it to be actionable, it must be shown that either there is a false allegation of fact or comment based on a false supposition. A national daily newspaper carried an exclusive report stating that Senator Balbas received a house and lot located at YY Street, Makati, in consideration for his vote to cut cigarette taxes by 50%. The senator sued the newspaper, its reporter, editor, and publisher for libel, claiming the report was completely false and malicious. According to the senator, there is no YY Street in Makati, and the tax cut was only 20%. He claimed 1 million pesos in damages. The defendants denied actual malice, claiming privileged communication and absolute freedom of the press to report on public officials and matters of public concern. If there was any error, the newspaper said it would publish the correction promptly. Are the defendants liable for damages? No. Since Senator Balbas is a public person and the questioned imputation is directed against him in his public capacity, in this case, actual malice means the statement was made with knowledge that it was false or with reckless disregard of whether it was false or not. Since there is no proof that the report was published with knowledge that it is false or with reckless disregard of whether it was false or not, the defendants are not liable for damages. Borjal versus CA. Test for a valid governmental interference to freedom of expression. 1. Clear and present danger test. 2. Dangerous tendency test. 3. Grave but improbable danger test. 4. Balancing of interest test. 5. O'Brien test. 6. Direct incitement test. 7. Roth test on obscenity. 8. Miller test on indecent speech. Overbreadth doctrine. The overbreadth doctrine permits a party to challenge the validity of a statute even though, as applied to him, is not unconstitutional, but it might be if applied to others not before the court whose activities are constitutionally protected. It is a type of facial challenge that prohibits the government from achieving its purpose by means that sweep unnecessarily broadly reaching constitutionally protected as well as unprotected activity. Content-neutral regulation. Content-based restraint. Content-neutral regulation, merely concerned with the incidence of the speech, or one that merely controls the time, place, or manner, and under well-defined standards. No presumption of unconstitutionality. Test to be used. Intermediate approach. Content-based restraint. The restriction is based on the subject matter of the utterance or speech. The cast of the restriction determines the test by which the challenged act is assailed with. There is presumption of unconstitutionality. Note, the burden of proof to overcome the presumption of unconstitutionality is with the government. Test to be used, clear and present danger. Intermediate approach test. Used when the speech restraints take the form of a content-neutral regulation. Only if substantial governmental interest is required for its validity, because regulations of this type are not designed to suppress any particular message. They are not subject to the strictest form of judicial scrutiny, but an intermediate approach, somewhere between the mere rationality that is required of any other law and the compelling interest standard applied to content-based restrictions. Chavez versus Gonzalez. Distinguish between facial challenge and as-applied challenge. A facial challenge is a challenge to a statute in court in which the plaintiff alleges that the legislation is always and under all circumstances unconstitutional. and therefore void. It is an examination of the entire law, pinpointing its flaws and defects, not only on the basis of its actual operation to the parties, but also on the assumption or prediction that its very existence may cause others, not before the court, to refrain from constitutionally protected speech or activities. It is allowed only when it operates in the area of freedom of expression. Invalidation of the statute on its face, rather than as applied, is permitted in the interest of preventing a chilling effect on freedom of expression. Separate opinion of Justice Mendoza in Cruz versus Secretary of Environment and Natural Resources. An as-applied challenge, on the other hand, considers only extant facts affecting real litigants. Southern Hemisphere Engagement Network versus Anti-Terrorism Council. What is commercial speech? Is it entitled to constitutional protection? What must be shown in order for government to curtail commercial speech? Commercial speech is communication which involves only the commercial interest of the speaker and the audience, such as advertisements. Commercial speech is entitled to constitutional protection. Ayer Productions versus Capulong. Commercial speech may be required to be submitted to a governmental agency for review to protect public interests by preventing false or deceptive claims. Pharmaceutical and Healthcare Association versus Duque. Heckler's veto. Heckler's veto occurs when an acting party's right to freedom of speech is curtailed or restricted by the government in order to prevent a reacting party's behavior. The term heckler's veto was coined by University of Chicago professor of law Harry Calben. The heckler's veto involves situations in which the government attempts to ban protected speech because it might provoke a violent response. In such situations, the mere possibility of a violent reaction to protected speech is simply not a constitutional basis on which to restrict the right to speak. It may be in a guise of a permit requirement in the holding of rallies, parades, or demonstrations conditioned on the payment of a fee computed on the basis of the cost needed to keep order in view of the expected opposition by persons holding contrary views. Gorospe, citing Forsyth County versus Nationalist Movement. Freedom of assembly and petition. Rules on assembly in public places. 1. The applicant should inform the licensing authority of the date, the public place, where, and the time when the assembly will take place. 2. The application should be filed ahead of time to enable the public official concerned to appraise whether there are valid objections to the grant of the permit or to its grant, but in another public place. The grant or refusal should be based on the application of the clear and present danger test. 3. If the public authority is of the view that there is an imminent and grave danger of a substantive evil, the applications must be heard on the matter. And 4. The decision of the public authority, whether favorable or adverse, must be transmitted to the applicants at the earliest opportunity so that they may, if they so desire, have recourse to proper judicial authority. Freedom of religion. The guarantees to freedom of religion that are contained in the 1987 Constitution. Non-Establishment Clause. Number 2. Free Exercise Clause, or the freedom of religious profession and worship. Fernando filed an administrative complaint against his co-teacher, Amelia, claiming that the latter is living with a married man who is not her husband and is therefore committing disgraceful and immoral conduct in violation of the revised administrative code. Amelia claims that she and her partner are members of a religious sect that allows members of their congregation who have been abandoned by their respective spouses to enter marital relations under a declaration of pledging faithfulness. Having made such declaration, she argues that she cannot be charged with committing immoral conduct, or she is entitled to free exercise of religion under the Constitution. Rule on Amelia's liability. Amelia is not administratively liable. There is no compelling state interest that justifies inhibiting the free exercise of religious belief. The means used by the government to achieve legitimate objective is not the least intrusive means. Estrada versus Escritor. Non-establishment clause. The non-establishment clause means that the state should adopt a position of neutrality when it comes to religious matters. Political law reviewer. The non-establishment clause bars the state from establishing true laws and rules, moral standards according to a specific religion. Prohibitions against immorality should be based on a purpose that is independent of religious belief when it forms part of our laws, rules, and policies. Morality must be secular. Laws and rules of conduct must be based on a secular purpose. Exceptions to the non-establishment clause created by the Constitution. Article 6, Section 29. Prohibition on appropriation of public money or property for the use, benefit, or support of any religion. Number 2, Article 6, Section 28. Exemption from taxation of properties actually, directly, and exclusively used for religious purposes. Number 3, Article 14, Section 3, Number 3. Optional religious instruction in public elementary and high schools. Note: religious instruction in public schools. A. At the option of parents or guardians expressed in writing. B. Within the regular class hours by instructors that is designated or approved by religious authorities of the religion to which the children belong. C. Without additional cost to the government. Number 4, Article 14, Section 4, Number 2. Citizenship requirement of ownership of educational institutions, except those established by religious groups and mission boards. Number 5, Article 6, Section 29, Number 2. Appropriation allowed where ecclesiastic is employed in armed forces, in a penal institution, or in a government-owned orphanage or leprosarium. Exceptions to the non-establishment clause as held by jurisprudence. Number 1. Government sponsorship of town fiestas. Some purely religious traditions have now been considered as having acquired secular character. Garces versus Estenso. Postage stamps depicting Philippines as the venue of a significant religious event. Benefits to the religious sect involved was merely incidental, as the promotion of Philippines as a tourist destination was the primary objective. That is number 2. Aglipay versus Ruiz. Ang Ladlad is an organization composed of men and women who identify themselves as lesbians, gays, bisexuals, or transgendered individuals. Ang Ladlad applied for registration with the COMELEC to participate in the party-list election. The COMELEC dismissed the petition on moral grounds, stating that the definition of sexual orientation of the LGBT sector makes it crystal clear that petitioner tolerates immorality which offends religious belief based on the Bible and the Quran. Ang Ladlad argued that the denial of registration insofar as it justified the exclusion by using religious dogma violated the constitutional guarantees against the establishment of religion. Is this argument correct? Yes. It was a grave violation of the non-establishment clause for the COMELEC to utilize the Bible and the Quran to justify the exclusion of Ang Ladlad. Our Constitution provides in Article 3, Section that no law shall be made respecting an establishment of religion or prohibiting the free exercise thereof. At bottom, what our non-establishment clause calls for is government neutrality in religious matters. Clearly, governmental reliance on religious justification is inconsistent with this policy of neutrality. Ang Ladlad versus COMELEC. Lemon Test. The Lemon Test is a test to determine whether an act of the government violates the non-establishment clause. To pass the Lemon Test, a government act or policy must 1. Have a secular purpose, 2. Not promote or favor any set of religious belief or religion generally, and 3. Not get the government too closely involved with the religion. Lemon versus Kurtzman. Differences between establishment and accommodation. Establishment entails a position action on the part of the state. Accommodation, on the other hand, is passive. In the former, the state becomes involved through the use of government resources with the primary intention of setting up a state religion. In the latter, the state, without being entangled, merely gives consideration to its citizens who want to freely exercise their religion. Free Exercise Clause. Test. benevolent neutrality approach. Benevolent neutrality is an approach that looks further than the secular purpose of government action and examines the effect of these actions on religious exercise. Benevolent neutrality recognizes the religious nature of the Filipino people and the elevating influence of religion in society. At the same time, it acknowledges that government must pursue its secular goals. The wall of separation is meant to protect the church from the state. It believes that with respect to governmental actions, accommodation of religion may be allowed, not to promote the government's favored form of religion, but to allow individuals and groups to exercise their religion without hindrance. What is sought is not a declaration of unconstitutionality of the law, but an exception from its application. Estrada versus Escritor. Clear and present danger test. The question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. Schenck versus United States. Compelling state interest test. Used to determine if the interests of the state are compelling enough to justify infringement of religious freedom. It involves a three-step process. 1. Has the statute or government action created a burden on the free exercise of religion? Number 2. Is there a sufficiently compelling state interest to justify this infringement of religious liberty? 3. Has the state, in achieving its legitimate purposes, used the least intrusive means possible so that the free exercise is not infringed any more than necessary to achieve the legitimate goal of the state? Note: the compelling state interest test is used in cases involving purely conduct based on religious belief. Number 4. Conscientious objector test. Who is a conscientious objector? A conscientious objector is an individual who has claimed the right to refuse to perform military service on the grounds of freedom of thought, conscience, and/or religion. International Covenant on Civil and Political Rights. Section 23, paragraph 3 of the RH law mandates medical practitioners who are conscientious objectors to refer those patients who are seeking information regarding reproductive health programs and services to another medical practitioner, rule on the constitutionality of the provision. It is unconstitutional. The court is of the view that the obligation to refer, imposed by the RH law, violates the religious belief and conviction of a conscientious objector. Once the medical practitioner, against his will, refers the patient seeking information on modern reproductive health products, services, procedures, and methods, his conscience is immediately burdened, and he has been compelled to perform an act against his belief. Accordingly, a conscientious objector should be exempt from compliance with the mandate of RH law. If he would be compelled to act contrary to his religious belief and conviction, it would be violative of the principle of non-coercive enshrined in the constitutional right to exercise of religion. The same holds true with respect to non-maternity specialty hospitals and hospitals owned and operated by a religious group and healthcare service providers. Imbong versus Ochoa. Liberty of abode and freedom of movement. Limitations to the exercise of the right to liberty of abode. The liberty of abode may be impaired only upon lawful order of the court and within the limits prescribed by law. Limitations on the right to travel. Authorities who may impose such limitations. The constitutional right to travel may be impaired in the interest of national security, public safety, or public health. It is settled that only a court may issue a whole departure order against an individual addressed to the Bureau of Immigration and Deportation. However, administrative authorities such as passport officers likewise curtail such right. Right to return to one's country, not a constitutionally protected right. The right to return to one's country is not among the rights specifically guaranteed in the Bill of Rights, which treats only of the liberty of abode and the right to travel. Nevertheless, the right to return may be considered as a generally accepted principle of international law, and under the Constitution is part of the law of the land. However, it is distinct and separate from the right to travel and enjoys a different protection under the International Covenant of Civil and Political Rights, Marcos versus Manglapus. Several criminal complaints were filed against former President Gloria Macapagal Arroyo, GMA, before the DOJ. In view thereof, DOJ Secretary Lima issued Watch List Orders, or WLO, pursuant to her authority under DOJ Circular No. 41, which was issued pursuant to the rulemaking powers of the DOJ in order to keep individuals under preliminary investigation within the jurisdiction of the Philippines. Subsequently, GMA requested for the issuance of Allowed Departure Orders, ADO, so that she may be able to seek medical attention abroad. Before the resolution of her application for ADO, GMA filed a petition with prayer for the issuance of a TRO, seeking to annul and set aside DOJ Circular No. 41 and WLOs issued against her for being unconstitutional. A TRO was issued, but GMA was prevented from leaving the country. Is DOJ Circular No. 41 unconstitutional for being a violation of the right to travel? Yes. The DOJ has no authority to issue DOJ Circular No. 41, which effectively restricts the right to travel through the issuance of WLOs and HDOs, hold departure orders. There are only three considerations that may permit a restriction on the right to travel: national security, public safety, or public health. Further, there must be an explicit provision of statutory law or rules of court providing for the impairment. DOJ Circular No. 41 is not a law. It is not a legislative enactment, but a mere administrative issuance designed to carry out the provision of an enabling law. DOJ is not authorized to issue WLO and HDO to restrict the constitutional right to travel. There is no mention of the exigencies stated in the Constitution that will justify the impairment. The provision simply grants the DOJ the power to investigate the commission of crimes and prosecute offenders. It does not carry the power to indiscriminately devise all means it deems proper in performing its functions without regard to constitutionally protected rights. DOJ cannot justify the restraint and the liberty of movement imposed by the circular on the ground that it is necessary to ensure presence and attendance in the preliminary investigation of the complaint. There is no authority of law granting the power to compel the attendance of the subjects of a preliminary investigation pursuant to its investigatory powers. Its investigatory power is simply inquisitorial and unfortunately not broad enough to embrace the imposition of restraint on the liberty of movement. Right to information. The right only affords access to records, documents, and papers, which means the opportunity to inspect and copy them at his expense. The exercise is also subject to reasonable regulations to protect the integrity of public records and minimize disruption of government operations. The right to information is validly exercised when the access is for a lawful purpose and is subject to reasonable conditions by the custodian of the records. Requisites before the right to information may be compelled by writ of mandamus. 1. The information sought must be in relation to matters of public concern or public interest, and 2. It must not be exempt from law, from the operation of the constitutional guarantee. Note: the court has already declared that the right to information does not extend to matters acknowledged as privileged information under the separation of powers, which include presidential conversations, correspondences, or discussions during closed-door cabinet meeting. Sereno versus Committee on Trade and Related Matters. Publication of laws and regulations. Requiring publication of policy issuances in the judiciary. The assailed JBC policy need not be filed in the owner because the publication requirement in the owner University of the Philippines Law Center Office of the National Administrative Register is confined to issuances of administrative agencies under the executive branch of the government. Since the JBC is a body under the supervision of the Supreme Court, it is not covered by the publication requirements of the Administrative Code. Nevertheless, the assailed JBC policy requiring 5 years of services judges of first-level courts before they can qualify as applicants to second-level courts should have been published. The assailed policy involves a qualification standard by which the JBC shall determine proven competence of an applicant. It is not an internal regulation because if it were, it would regulate and affect only the members of the JBC and their staff. Notably, the selection process involves a call to lawyers who meet the qualifications in the Constitution and are willing to serve in the judiciary to apply to these vacant positions. Thus, it is but a natural consequence thereof that potential applicants be informed of the requirements to the judicial positions so that they would be able to prepare for and comply with them. Freedom of association. The right of the people, including those employed in the public and private sectors, to form unions, associations, or societies for purposes not contrary to law, shall not be abridged. Section 8, Article 3, 1987 Constitution. The right to form associations shall not be impaired without due process of law. It is therefore an aspect of the general right of liberty. More specifically, it is an aspect of freedom of contract, and insofar as associations may have for their object the advancement of beliefs and ideas, freedom of association is an aspect of freedom of expression and of belief. Note: the right to form or join unions or associations includes the right not to join, or, if one is already a member, to disaffiliate from the association. Right to strike is not included in the right to form associations by government employees. The employment of government employees is governed by law. It is the Congress and administrative agencies which dictate the terms and conditions of their employment. The same is fixed by law and circulars and thus not subject to any collective bargaining agreement. Non-impairment clause. The law impairs the obligation of contract if 1. It changes the terms and conditions of a legal contract, either as to the time or mode of performance, or 2. It imposes new conditions, or dispenses with those expressed, if it authorizes for its satisfaction something different from that provided in its terms. Why is then an impairment clause considered dead letter law? It is settled that the constitutional guarantee of non-impairment is limited by the exercise of the police power of the state. In the interest of public health, safety, morals, and general welfare, it is a basic rule in contracts that the law is deemed written into the contract between the parties. The incorporation of regulations into contracts is a postulate of the police power of the state. Rights of suspects. Miranda rights. Right to which a person under custodial investigation is entitled. 1. Right to remain silent. 2. Right to competent and independent counsel, preferably on his own choice. 3. Right to be reminded that if he cannot afford the services of counsel, he would be provided with one. 4. Right to be informed of his rights. 5. Right against torture, force, violence, threat, intimidation, or any other means which vitiate the free will. 6. Right against secret detention places, solitary incommunicado, or similar forms of detention. 7. Right to have confessions or admissions obtained in violence of these rights considered inadmissible in evidence. Availability of Miranda rights. During custodial investigation, note: as soon as the investigation ceases to be a general inquiry into an unsolved crime and direction is aimed upon a particular suspect, as when the suspect who has been taken into police custody and to whom the police would then direct interrogatory questions which tend to elicit incriminating statements. Or, 2. Critical pretrial stage. Instances when Miranda rights are not available. 1. During a police lineup, unless admission or confessions are being elicited from the suspect. 2. During administrative investigations. 3. Confessions made by an accused at the time he voluntarily surrendered to the police or outside the context of a formal investigation. 4. Statements made to a private person. 5. Forensic investigation is not tantamount to custodial investigation, therefore, Miranda rights is not applicable. 6. During preliminary investigations. Doctrine of the fruit of the poisonous tree. The doctrine provides that once the primary source, the tree, is shown to have been unlawfully obtained, and the secondary derivative evidence, the fruit, derived from it, is also inadmissible. The rule is based on the principle that evidence illegally obtained by the state should not be used to gain other evidence, because the originally illegally obtained evidence taints all evidence subsequently obtained. Rights that may be waived: 1. Right to remain silent, and 2. Right to counsel. Rights that may not be waived: the right of the accused to be given the Miranda warnings. Requisites of valid waiver: 1. Made voluntarily, knowingly, and intelligently; 2. In writing; and 3. With the presence of counsel. Admissibility as evidence of confessions given to news reporters and/or media and videotaped confessions. Confessions given in response to a question by news reporters, not policemen, are admissible. Where the suspect gave spontaneous answers to a televised interview by several press reporters, his answers are deemed to be voluntary and are admissible. Videotaped confessions are admissible where it is shown that the accused unburdened his guilt willingly, openly and publicly in the presence of the newsman. Such confessions do not form part of confessions in custodial investigation, as it was not given to policemen but to media in an attempt to solicit sympathy and forgiveness from the public. Constancio and Berry were charged with the crime of rape with homicide committed against AAA. During the trial, Amparo, a news reporter, testified that he personally interviewed Berry. Amparo declared that during his interview, Berry revealed what happened the night AAA was killed. Attorney Suarez testified that during the custodial investigation, he advised Berry of his constitutional rights and the consequence of his statements. Berry then executed an extrajudicial confession, which was embodied in a sinumpang salaysay. However, at the trial, Berry attested that the sinumpang salaysay was false and claimed that he was threatened into signing the same. Is the confession admissible? Yes. The court believed that Berry's confession is admissible because it was voluntarily executed with the assistance of a competent and independent counsel in the person of Attorney Suarez, following Section 12, Article 3 of the Constitution. In default of proof that Attorney Suarez was negligent in his duties, the court held that the custodial investigation of Berry was regularly conducted. There was no ample proof to show that Berry's narration of events to Amparo was the product of intimidation or coercion. Berry's extrajudicial confession to Amparo, a news reporter, is deemed voluntary and is admissible in evidence as it was not made to the police authorities or to an investigating officer. People v. Constancio. Rights of the accused: 1. Due process. 2. Be presumed innocent. 3. Be heard by himself and counsel. 4. Be informed of the nature and cause of the accusation against him. 5. A speedy, impartial, and public trial. 6. Meet the witnesses face to face. 7. Have compulsory process to secure attendance of witnesses and production of evidence on his behalf. 8. Against double jeopardy. And 9. Bail. Criminal due process. Requisites of criminal due process. 1. Accused is heard by a court of competent jurisdiction. 2. Accused is proceeded against under the orderly processes of law. 3. Accused is given notice and opportunity to be heard. 4. Judgment must be rendered after lawful hearing. Bail. The following are entitled to bail: 1. Persons charged with offenses punishable by death, reclusion perpetua, or life imprisonment when evidence of guilt is not strong. 2. Persons convicted by the trial court pending their appeal. 3. Persons who are members of the AFP facing a court-martial. Grounds for denial of bail: if the penalty imposed by the trial court is imprisonment exceeding 6 years, the accused shall be denied bail, or his bail shall be cancelled upon a showing by the prosecution with notice to the accused of the following or other similar circumstances: a. That he is a recidivist, quasi-recidivist, or habitual delinquent, or has committed the crime aggravated by the circumstance of reiteration. B. That he has previously escaped from legal confinement, evaded sentence, or violated the conditions of his bail without valid justification. C. That he committed the offense while under probation, parole, or conditional pardon. D. that the circumstances of his case indicate the probability of flight if released on bail, or E, that there is undue risk that he may commit another crime during the pendency of the appeal. Presumption of innocence. Equipoise rule. When the evidence of both sides is equally balanced, the constitutional presumption of innocence should tilt the scales in favor of the accused. In order that circumstantial evidence may warrant conviction, the following requisites must concur. 1. There is more than one circumstance. 2. The facts from which the inferences are derived are proven. And 3. The combination of all the circumstances is such as to produce conviction beyond reasonable doubt. Right to be heard. It means the accused is amply accorded legal assistance extended by counsel who commits himself to the cause of the defense and acts accordingly. It is an efficient and truly decisive legal assistance and not simply a perfunctory representation. Right to assistance of counsel. Elements of the right to counsel. 1. Court's duty to inform the accused of his right to counsel before being arraigned. 2. It must ask him if he desires the services of counsel. 3. If he does not, and is unable to get one, the court must give him one. If the accused wishes to procure private counsel, the court must give him time to obtain one. And 4. Where no lawyer is available, the court may appoint any person resident of the province of good repute for probity and availability. Note: while investigations conducted by an administrative body may at times be akin to a criminal proceeding, the fact remains that under existing laws, a party in an administrative inquiry may or may not be assisted by counsel, irrespective of the nature of the charges and of petitioner's capacity to represent herself, and no duty rests on such body to furnish the person being investigated with counsel. The right to counsel is not always imperative in administrative investigations, because such inquiries are conducted merely to determine whether there are facts that merit the imposition of disciplinary measures against erring public officers and employees, with the purpose of maintaining the dignity of government service. Note: assistance of counsel is not mandatory in a police lineup. The right to counsel commences from the moment an investigating officer starts to ask questions to elicit information or confession or admission. Gamboa versus Judge Cruz. Right to be informed of the nature and cause of accusation. Requisites for properly informing the accused of the nature and cause of accusation. 1. Information must state the name of the accused. 2. Designation given to the offense by statute. 3. Statement of the acts or omissions so complained of as constituting the offense. 4. Name of the offended party. 5. Approximate time and date of commission of the offense. 6. Place where offense was committed. And 7. Every element of the offense must be alleged in the complaint or information. Variance doctrine. In spite of the difference between the crime that was charged and that which was eventually proved, the accused may still be convicted of whatever offense that was proved, even if not specifically set out in the information, provided it is necessarily included in the crime charge. Teves versus Sandiganbayan.